Hi, yes. My name is Kathy Martin. I'm from Norman, Oklahoma. And I started working on CAFOs in 1998, totally by accident. I was not planned. And from there, word of mouth, I ended up going to Kansas and Colorado. Then there was a big facility in Utah, the Circle 4 Farms. And I got called out to look at the waste management system there. And before you know it, after 25 years, I've worked in 25 states. So I know a lot about poop, and I know a lot about the politics of trying to fight CAFOs. This one. Oh, gosh, thank you. She is an angel. All right, so just briefly, let's get started on what are we looking at? Across the country, there are a couple of different models for environmental regulation and permitting. One of them is for when it comes to CAFOs, is to have the permits issued through a Department of Agriculture, and then the actual permits enforced through an environmental agency, like you have here in Ohio. There's only another state in your Great Lakes region that does it like that, and that's Illinois, and it's a horrendous system. It's very difficult for an agency that its main mission is to promote agriculture to also regulate it. That's why we want to have all of the environmental regulations in an environmental agency that has no conflict in their overarching mission statement. As you will know, a lot of permits, we just think, oh, there's a construction permit and an operating permit. But how do we get involved in that process? And so the more people get involved, the more industry doesn't like it. So they go and get some new kinds of permits, such as general permits, where that permit is issued. It's a standard generic permit language. It's passed once every 5 years. It's put in a drawer. And then any industry that wants to operate under that general permit submits a notice of intent. And in some states, the notice of intent is publicly noticed. Other states, not so much. In most states, when there's an NOI, there's usually no opportunity for public comment or appeal of that individual facility's notice of intent. But in Indiana, interestingly enough, their CAFO permitting system is a general permit, but they have full public participation. So public comment, public hearing, and adjudicatory hearing. So it's unique there. Also, in different states, there's different triggers. You have to go back to the history of the CAFO Act. You can always go back to the mothership, which is the Clean Water Act, and EPA's definition of what a CAFO was. And they put something called effluent limitation guidelines for CAFOs, which in effect was saying a livestock facility is prohibited from discharge from the production site, period, into waters of the US. And then they can land apply the waste, and there can be a contaminated agricultural stormwater runoff that is not pollution if the facility is properly designed, constructed, maintained, operated according to the rules, and that the manure is land applied according to agronomic rates of the crop. So there's a lot of places to trip up, right? And that's what I did as an engineer looking at waste management systems, is looking at where the facility tripped up. So this is just to keep us all on the same page. The US EPA's definition of a large CAFO for dairy, which is what we're talking about today, is 700 mature cows equals 1,000 animal units. I wanted you to just look at this list of all the other animals, and I want you to understand that as an engineer and a little bit on the spectrum, I calculated each of these types of animals, the volume of manure, the pounds of manure, the pounds of nitrogen, and the pounds of phosphorus, according to these numbers. And there's absolutely no correlation between the amount of nitrogen each group of animals and these numbers. So these numbers are basically developed, I guess, by size, okay? Like a beef cattle is big, so that'll be 1,000. A swine is littler, so that'll be 40%. And I just want you to know that there's not a lot of when you scratch the surface of that veneer, there's nothing underneath. Okay, real quickly, how long do I have till?
9:20.
9:20, okay. So just quickly, going around the states, which is what Sandy asked me to do. So like I said, in Illinois, they have something called the Livestock Management Facilities Act. God, I was like, how do I, LMFA, sorry. And it's interesting, so that's triggered, starting at 50 animal units to 1,000 animal units for setbacks. But don't get like excited about that, because nobody has been able to stop a CAFO in Illinois, but by setbacks. They do have, the Department of Ag doesn't issue a permit, but approves the construction application. And then once they're built, then the responsibility goes to the Illinois EPA to enforce the Clean Water Act. So when you're complaining after the facility's built, you have to understand that the agency that's in charge of enforcement had no control over where it was built, how it was built, how it's been operated, which is ridiculous, right? In Indiana, God bless them, Indiana Department of Environmental Management, they have their CAFO system. So they do acknowledge the medium CAFO, which is 300 animal units or more. So think about half the number of dairy cows. And that would be a state triggered permitting issue. And then the 1,000 animal units, of course, triggers any federal requirements. I went to go back, sorry, in Illinois, I was trying to combine local control. The idea of local control in Indiana is prior to the construction being approved, there's something called 8 siting criteria that the county supervisors are in charge of holding a public meeting if the facility is large enough size. There's 8 siting criteria. The public can be fully engaged at that point. And if there's a public hearing, the applicant comes, the Department of Agriculture comes, they present the facility. I've been in meetings where there's 200 people, media all over the place. You can ask questions of the applicant. None of it is, nobody's like sworn to tell the truth. It's not an adjudicatory process, but it is a highly interactive process. And then the county's supervisors write a recommendation to the state to deny or approve the application. And of course, it's non-binding. So even if you were successful at getting it, your county supervisors to write a scathing letter back to the state can just ignore it. But it is an excellent media opportunity because, like I said, you can ask questions of the applicant. So there's always, silver lining. But in Indiana, of course, they do have county local control. Most of the counties have conditional use permits related to CAFOs by this time. And so that's where you want to start your business. And I've worked in both of those states extensively. Now, Michigan, and interestingly enough, I have not worked in, so I'm just put the name of the agency there. Minnesota, I have worked on CAFOs there. And they also have a medium trigger, the 300 animal units. She said I could point, but you can kind of see that. So the medium trigger is called a CSF, and in Minnesota, they're called feedlots, just so you know. And then in Minnesota, they can delegate the permitting process to a county if it's less than 1,000 animal units. So that's kind of interesting because you have some more local control there. So that's unique. And I think the purpose of me telling you all these different states is nobody has a perfect system, but some have really good parts and some have really horrible parts. So if we were ever to join as a coalition and find the most ideal set, this is what you want to do. And again, New York, I have not worked on any CAFOs there. There was an issue about, I guess there was a lawsuit in 2019 that some suing to get the CAFOs to be registered. And this has to do with whether or not under the Clean Water Act, the public has a right to see the nutrient management plan. Okay, so if there's an NPDES permit, there's a nutrient management plan that was, we call it the water keeper's decision. And so I think this was a continuation of that lawsuit, but in the state. So even though the lawsuit says, yep, you have to have public notice on the nutrient management plan, What happened is all the facilities said, well, then we don't want that permit anymore. We want a state permit. And so nobody gets to see the nutrient management plan. And I know I'm not telling you anything you haven't heard before. There's always tricks. As soon as you're successful, they just find another way to avoid transparency. Ohio, I'm going to leave it to the person that's going to speak after me. Pennsylvania, I did a lot of work in Pennsylvania, probably for about 8 years. And they have a very interesting system. Yes, they have township ordinances, county. So actually there you start at the township level, which is very interesting. The counties are not as welcome, but the townships are. And if you want to try to get access to paperwork, they are the most circular. And then Wisconsin has construction operating under their DNR. And they have some really good rules. So let's talk about public participation, which I think is the most important thing. Is when you find out a CAFO is coming across the street from you, what do you do next? Well, you want to get access to the documents. You want to know if there's a hearing, if you know, how can you participate? And so all of these states have different processes, different levels of access online. And of course, when I started in 1998, everything was faxed. You had to go and make Xerox copies. And so anyway, everything was hard copy, which is not the case now, which is fabulous. So most permit applications now are submitted digitally, electronically. So they're there in the system of your agency. It's not very difficult for them to make it available to the public. Now, whether or not they have a searchable database, whether they have, you know, the sophistication of that determines how each state has made information available. Okay, so in Illinois, there's some online notice, but you have to beg, borrow, and steal to get a copy of the permit application. In Indiana, which is my favorite place, virtual filing cabinet, every single piece of paper that comes to IDEM gets scanned and put on the virtual filing cabinet. And so you can find letters and correspondence back and forth. You can find the permit applications, engineering drawings, inspection reports, compliance, everything you could possibly want 24/7. Very nice. Michigan, again, I'm not real familiar. They do have an ArcGIS CAFO map where you can go in and find where the CAFOs are in your area. And they have an Enviro portal that has access to certain things, but it doesn't look like you have access to everything. In Minnesota, very similarly, you can go in with, you know, when I Googled find a permit search in Minnesota, the last words that would have come to me are what's in my neighborhood, but that's what it's called. So again, when you talk about transparency, you're upset, you're getting online, you want to find out where the permit is, and the direct thing, the keyword search that you're going to use is never going to get you there, right? They do have an online public comment portal that only has a copy of the draft permit. So not the permit application, all of the details of, you know, what they're actually proposing. New York also has a ArcGIS system and a CAFO locator, but this one was very interesting. It's of course for the entire agency, and you can pick the CAFO as one of the layers of the GIS. And when you click on the dot and the pop-up window comes up and it says more information, when you click that, it sends you to a page that basically says the name and address and no links to anything. So dead end. Ohio, you have to ask, beg, borrow, and steal to get copies of the application. And they're going to play chicken with you till the deadline for public comments. Pennsylvania, some parts of the permit application are at the county conservation district. Some parts are in Harrisburg. If you call Harrisburg, they're going to say it's in the county. If you call the county, they're going to say it's Harrisburg. And they're going to send you zooming around until you go insane. Yeah. And then Wisconsin does have a very good searchable database for permit documents, inspections, and compliance reports. But you gotta know the special number, because if you search by the facility name, they may not have it exactly the way you typed it. And if you don't have it exactly the way they have it in there, it's gonna say no documents, even though you know there's 100 documents. Okay, so wrapping this up. So this is kind of what the Minnesota map looks like. And there's a little pop-up window and you see the hyperlink for more information. Here's a map of Indiana, kind of showing you where the CAFOs are according to their facility. I think this was, 2017, so it's very old. And then your Michigan ArcGIS map, where you can click on those dots and they'll take you to more information. And wrapping it up here, I think the most important thing in some of the rules are setbacks, right? So some states, they say, no, we do setbacks in the Clean Water Act, which is to waters of the state, wetlands, that type of thing. And they may have to property line and public and private water well. But any other kind of setback, like to residents and businesses, that's considered a state issue. And some states say, no, we're going to make that a county or local issue. So that's also different across the region. And I just wanted to tell you one funny thing about Illinois. A new facility in Illinois. So they come in one under the number, so they don't get any of the restrictions, right? They don't get any of the setback and they have good setbacks in Illinois. Then they can, if they can modify their facility, they can expand. And let me just read this to you. Expanding a facility where the fixed capital cost of the new components constructed within a 2-year period does not exceed 50% of the fixed capital cost of a comparable entirely new facility shall not be deemed a new facility. Okay. I'll tell you one example. There was a facility that had like a 40-year-old old style Tyson hog facility that maybe could have housed 100 hogs, totally dilapidated, totally grown over with weeds, half falling down. They priced that as if the whole thing was built brand spanking new today as the base value. And then they compared it using this. And so the guy could build a whole new barn of hogs and be expanding of a derelict facility. I kid you not. Okay, and then bring me back later and we can talk all about lagoon liners and leak detection, which is what I always looked at. I do want to say Wisconsin has the best leak detection under lagoons. All lagoons leak. Plastic liners, concrete liners, dirt liners, clay liners, they all leak. There's all pollution. And if you give me one more minute, in New Mexico, I'm working on something called the Dona Ana Dairy Abatement Plan. So south of Las Cruces, there's about 10 miles of dairies, 13 dairies, they're one right after each other. They've all polluted the groundwater because in New Mexico, every dairy has to have a minimum of an up gradient, groundwater monitoring well, down gradient of the lagoons and the land application areas. So and they have to take samples. Yes, it is the only state that I'm aware of that automatically requires monitoring. There's no ifs, ands, or buts about it. So they have a lot of data. The nitrate pollution under these dairies was up to 100 parts per million and more. So they had to go under abatement strategy, and I was involved in the stage 2 approval. It's there's 150 monitoring wells. The quarterly monitoring report is 600 pages long. So it's very intense, but yes, there is pollution under plastic lined lagoons, clay lined lagoons, unlined lagoons, concrete lagoons. Thank you.
We're going to hold the questions till the end of these groups. Okay, so we're going to do them one after the other. I think Kathy's pretty amazing in her story, and her experience and knowledge are so helpful. So our next speaker is Adam Buskell from Midwest Advocates, and he's going to kind of fill us in on, I think, the Wisconsin scene. Yeah. Pretty much, which Wisconsin is really coming of age and being quite aggressive on the CAFO manure issue. Right there. So thanks for coming, Adam, and look forward to your speech. And by the way, just to let you know, this is David Ruck, who did the Lake Erie situation. He is gonna be doing some more, and
Dave Brooks in the back.
I'm sorry, David Bruck's back there. I saw, I didn't look.
Trying to be low.
You know he's here.
Affiliate.
Yeah,
Affiliate. Oh, thank you.
you got it. Look at that.
It's just kind of tight.
Yeah. All right, excellent. Thank you.
That's right. Sorry, David.
All right. Hi, all. My name is Adam Voskel. I'm a staff attorney at Midwest Environmental Advocates. We are a nonprofit law firm based in Madison. We've got, I want to say, do I have a slide? Yeah. So we have only 4 attorneys on staff, but we, because ag has been such a historic, longstanding practice and issue in Wisconsin, we have 1 dedicated attorney to exclusively work on the subset of CAFOs within agriculture in the state. It's always interesting hearing people talk about Wisconsin agriculture because I'm kind of a grass is always greener person where I meet with, it feels like the world is falling and all the water is polluted in Wisconsin. And then I realize like it's not always that bad, but it is rough. There are days where it's challenging. But I'm here to talk to you about what's going on in Wisconsin for CAFOs. And before I get too far into it, I actually had a chance to sit in on a call with Kathy. I'm not sure if any of you have, there you are, have had a chance to sit in with Kathy and regulators at times, but just laid into them. It was fantastic. About some spreading and some plans and some regs, nutrient management plan review, I think, over in Western Wisconsin. So like I said, MEA is a nonprofit environmental law firm. We work directly with community members. So as opposed to like membership organizations that may be litigating on behalf of folks, I'm driving out to random communities, random counties across the state, meeting with individuals and then, creating client groups and plaintiffs to bring litigation. So a bit of background before jumping into how CAFOs are regulated. This is a map it's a somewhat old map of CAFOs in Wisconsin. I want to say it's 2020. It seems like every year and sometimes multiple times a year when I'm giving presentations like this, these numbers are changing. I believe about a year ago, we were at 327 CAFOs. We're now at 335. And one of the really interesting things about both this map and CAFO distribution and CAFOs in Wisconsin in general is that they seem to, 1, be cited in some of the most sensitive regions of the state, and 2, they're kind of aggregated into certain areas. So if you look at the Door County area, the thumb up in, we call it Northeast Wisconsin, but I think you could just as easily characterize it as just East Central Wisconsin or something like that. That is an area where the depth to bedrock is anywhere from, a few inches. They've got like a 0 to 12 inch spreading standard in some of these areas, to a few feet. And it's karstic topography. So it's fractured bedrock, it's carbonate, meaning that anything spread on fields almost instantaneously makes it into groundwater. And directly into neighbors' homes, private drinking water wells. Up in Kewaunee and Door and Brown County, less Brown because that's where Green Bay is, but at least Kewaunee and Door, I think 100% of the drinking water is pulled from private drinking water wells. So each individual wells on site, and they're all not, the number of testing isn't necessarily extremely high, and the water moves so quickly that people can have safe drinking water in the morning. And then if a CAFO is spreading in the morning, they can have extremely contaminated brown water events in the afternoon and evening.
Are those all permanent?
So I want to say, yes, those are all the permitted CAFOs. The like yellow triangles up in Northwest are Jenny O turkey CAFOs, but those are all the permitted operations.
So you don't know how many.
No, we worked with Environmental Working Group about 2 years ago. They did an analysis of just kind of doing satellite imaging, and I think came to the realization that there were a lot more, but they didn't necessarily focus on that so much as they just focused on the amount of nutrients that were likely being produced by any of those individual operations. I think our DNR is states that they don't anticipate that there are many unpermitted CAFOs. I don't know that I would necessarily agree with that, but that tends to be their position. So I wanted to jump into some of the nutrient contamination issues that we see in Wisconsin. I'm gonna close this. There we go. So first, some of the surface water impacts from CAFOs, and I realize the room that I'm talking to is probably aware a lot of a lot of this stuff kind of in the abstract, but really wanted to focus in on some of these topics. So up in on the, I guess from the right hand side of the screen, that's Kewaunee County, and what that comes from the study that we did with Environmental Working Group. They mapped all of the spreading fields in the county, and then did satellite imaging and looked at all of the livestock housing facilities in the area. And they believe it's pretty accurate, kind of calculated out the likely nutrients that were being produced overall, and then just from where they were being produced, applied them at maximum levels to all of those fields. And then also included looking at the ag census, I believe, fertilizer purchase that came into the county as well. And basically determined that if you look at the bottom left where the yellow is, those are fields that aren't maxed out with nutrient application. And all of that orange are the fields that were fully maxed out, which means Kewaunee is generating and importing more nutrients that than the county, like all of the agricultural fields have the ability to receive. And, you know, to some extent, I'm not going to say it makes sense, but the CAFOs at the north part of the county do a lot of their spreading up in Door as well. So it seems like they recognize that they're overspreading in the county itself, and they're moving into an even more sensitive area. The Door County area is some of the shallowest depth to bedrock and some of the most karstic area of the state. It's a bit less populated than Kewaunee, but pretty concerning the amount of nutrients that are getting spread in that area. And then on the left side of the screen are the that's a relatively old picture. I want to say it's 2015. And those are all of the watersheds that are impaired for phosphorus. And so it's gotten more. There is more impairment since then. We've had more TMDLs up in the Kewaunee region. We just had an approved TMDL kind of all along the Northeast Lakeshore. Looking at groundwater, which is what a lot of my work tends to focus on, and I'll explain why in a bit. We see pretty substantial nitrate levels and bacteria levels that our clients come to us with. Like I said, up in Kewaunee County, we had probably like a decade-long litigation up there, working with a number of folks, and some studies came out that indicated that because of that, the topography and how fast water spreads and the amount of spreading that that occurs, something like a third of the wells are going to test above safe drinking water levels at any time, but it's not the same 1/3 of all of those wells. That's how fast everything moves. And so, you know, people have thought about well remediation, ways to have more likely access to safe and clean drinking water. But the problem is that a lot of those state requirements require testing to show that your well is exceeding levels, and they're not really able to qualify because they don't know if or when their well is going to be contaminated. It's been it's a challenge for those folks. And that's just kind of a bit of background to get into and explain where I'm coming from, which is how CAFOs are regulated in the state. As everyone I think is aware, it starts with the Clean Water Act, but I'm going to focus a lot more on what's going on in Wisconsin. So in Wisconsin, we have our WIPDES permit, our Wisconsin Pollutant Discharge Elimination System permit. Wisconsin was delegated in 1977, I believe, to operate their own the NIPDES version, the state version of the NIPDES program. And one interesting caveat that I believe I get to in the next slide is that Wisconsin also includes the regulation of groundwater and the protection of groundwater in their state permits. And that's really beneficial because it wraps in all of the spreading fields into all of our state permits. So DNR is regulating the spreading that's happening on fields as well. That's done in our administrative code NR 151. And then somewhat separate from that, but I think still important, we have these ways for local control as well. First, livestock facility siting, which is this interesting interplay between state and local government. So the legislature passed livestock facility siting in the early 2000s, basically saying local governments didn't have the ability to regulate the location of livestock facilities, except for this default set of regulations that's passed by our Department of Agriculture. So not our DNR, which does everything else, but our Department of Agriculture. But it's an opt-in system. So the local governments have to choose whether or not they actually want to engage in that process. And if they do, they just kind of wholesale adopt these pre-existing standards with some very limited opportunities for more specific regulation. But what we're seeing now as kind of a result of that withdrawal of local authority, and at some point the counties and towns around the state got fed up with being told they couldn't do something, is we're seeing this push for local zoning ordinances that don't regulate necessarily the siting of operations, but more how they're operating. We're calling them CAFO operations ordinances, and they've popped up a lot in the last year or so. So we have this, it's not holistic, it's not perfect, but it is kind of a number of different sets of authorities that folks are pushing on, that we're working with state regulators and local communities to try to find ways to affect CAFO operations and limit spreading in a multitude of ways. So yeah, this is just I think my most text heavy slide, but this is just, I think, important to know kind of the background of our WIPD's permit. So like I said, point source, and like in the Clean Water Act, does include CAFOs, but our waters of the state, which is Wisconsin Statute 2810118, is this really long phrase. It's all the surface waters, but it's marshes, it's groundwater, it's intermittent streams, it's artificial waters as well. So it ends up being basically ropes in everything. And we've relied on that definition of the state or definition of waters of the state, as well as our state groundwater law in a lot of the litigation that we've brought in recent years. CAFOs are regulated in basically by chapters NR 243 and 151. And we've got this NR 243.12 sub 1 that basically says a CAFO needs to have a WIPD's permit. And that is relevant now because I'm actively litigating a case where the CAFOs are pushing back on that and trying to adopt what's happened in other states, the waterkeeper decision, the pork producer decisions from that challenged EPA's requirement for CAFOs to have permits in like 2002 and 2007. So this is, I just wanted to, I always think it's interesting to put up just the cover sheet of our WIPD's permits. WIPD's permits are individual permits, not general permits. So each CAFO is going to be seeking a permit. A lot of the terms end up being default. They're the exact same in each of them, but there's an opportunity for public comment. And we regularly are pushing for better terms, largely focused on monitoring around the production facility, as well as monitoring on ground spreading or land spreading fields. It hasn't happened very often, but it does happen occasionally, which is why it was interesting to hear about New Mexico.
Ohio used to do that back before 2002, before.
The waterkeeper, yeah.
Well, yeah, waterkeeper and state legislation.
No. Yeah, like I said, we're fighting those arguments right now. And one of the interesting things is our legislature under the previous governor adopted or passed some laws that basically made it impossible for our DNR, or made it very challenging for our DNR to pass new regulations. And so as opposed to Ohio or other states that may have lost the ability to have individual permits or require CAFOs to hold NIPD's or WIPD's permits, that may have kind of tried to backfill with other permitting systems, there is a concern that should a court adopt the plaintiff's argument in the case that we're in, ultimately the result will be no permitting program, right? They won't be obligated to seek WIPD's permits. They, DNR is limited in their capacity to find individually that every CAFO is discharging to a water in order to require that CAFO to get permits, and they're not going to have the capacity to pass a new rule or a new permitting program that kind of is separate from the WIPD's permitting program. Our permit applications, all of this stuff, as Kathy mentioned, is available on I call it the e-permitting site. The DNR calls it their SharePoint, which is just a cloud storage site. And you already flagged the other caveat of this, which is that to find any of these things, if you don't know the CAFO permit number, you have to try like 8 different iterations of their name, because sometimes it's they just say like the owner's name. It'll be like Bill's CAFO, or it'll be S&S CAFO or Jersey Land CAFO or Jersey CAFO. And it's just kind of up to them to decide how they want to input it into the system. And there's no consistency and there's no checking by DNR. So while all of those things are there, I often end up backfilling with public records requests to get the records, and that takes time. And you know, you kind of have to hope that you get it before the permit period or the comment period ends. So just to focus on a couple litigation developments, I don't know if I have, yep. So two major lawsuits happened in the last 4 years, I guess, at this point. The first being Kinnard Farms, which was a lawsuit related to a CAFO up in Kewaunee County. We started, that lawsuit began in 2012, went through an administrative process where an administrative law judge ruled in 2014 that calling the groundwater quality crisis in Kewaunee County a massive regulatory failure, and ordering that a specific CAFO, Kinnard Farms in this instance, have groundwater monitoring at their land spreading fields, particularly those that were adjacent to a number of the folks that had just extreme levels of bacterial contamination. And then also that the CAFO have an animal unit cap, basically indicating like they can't get any bigger than this. There's a long procedural history that gets very strange and very wonky that I won't bore you with, but it eventually made its way to the Supreme Court. And in July of 2021, the court affirmed our Department of Natural Resources authority to require that groundwater monitoring and the animal limit in that CAFO, but also noted that the DNR was more broadly empowered to include those terms in other CAFO permits. So it wasn't specific to that CAFO. And so since 2021, we've been pushing the department to identify the permits that, you know, are really, they're spreading in susceptible areas, or there's a high percentage of contamination of private drinking water wells. I think since then we've seen like 3 total permits out of the 50 or so in the last 4 years that have been issued. So it's slow. DNR hasn't developed guidelines for when they include those things. It really seems to be ad hoc based on the specific permit drafter. But it is, you know, trending in a better direction, I guess, to say the least. And then the other permitting litigation update, which we received a victory in at the circuit court a couple months ago at this point, is that that argument that DNR can require CAFOs to seek and hold a WIPD's permit, you know, pushing back on the decisions of the pork producer and water keeper decision. This idea that because CAFOs, particularly in Wisconsin, are discharging not just to surface waters, but to groundwater, and groundwater is included in WIPD's permits, our DNR is, you know, has the authority to say every CAFO, no matter what, has to hold a WIPD's permit. That was at the circuit court. We got a ruling in our favor in January. It's been appealed and is now in front of the Court of Appeals very early on in the process. No briefing has begun yet. There's been some minimal spill enforcement, I'll note. It doesn't happen very often, and it usually requires neighbors, down gradient or downstream residents to like identify fish kills and then note to DNR to send someone out. And then DNR will investigate, usually to no one's satisfaction. The CAFO thinks they're being harassed, and the folks are noting like there's extreme degradation, and you find them $10,000. So it doesn't happen very often, and we've been trying to find ways to get better enforcement, but I think as a lot of folks know, it becomes relatively hard with changes that have been made to like federal laws like CERCLA, challenges with RCRA. There's just, it's hard to get enforcement from the private citizen level to be meaningful. Just a couple more slides that I'll breeze through before handing it over to whoever's next. Just to note, some of the alternative ways that we've been thinking about this other than WIPD's permits is MEA on behalf of a number of folks filed a Safe Drinking Water Act petition in 2014, trying to find ways to get clean and safe drinking water to folks in Kewaunee County. I would say there was mixed success. We saw additional spreading restrictions occur on the most susceptible areas in 15 counties in that northeast area of the state. However, there's been minimal improvements other than that. For a brief period of time, there was like a water refill, like people could refill Culligan jugs in Kewaunee County. That program has since ended, and there's still pretty significant contamination up there, both nitrates and bacteria. But they created a number of work groups that developed reading materials, brochures, things like that, short-term solutions and better farming practices, things like that, that could be distributed to CAFO operators. But again, I think that the improvements have been relatively minimal. And then last thing I'll point out is just the local ordinances. We've got moratoria, livestock sighting, but the big one is the operations ordinances, where individual townships have taken it upon themselves to pass very, comprehensive ordinances that address things like air pollution, loss of property value, water contamination, setbacks, operating hours, transit, things like manure hauling. These 6 towns all banded together to pass like a findings of fact. That was the starting point for a lot of those ordinances. I think to date now, only 3 of those ordinances are still in operation or are still in effect because industry groups have so aggressively pushed back on them. We saw a couple just opted not to even pass the ordinance. And then one of the industry groups kind of like funded almost the campaigns for folks that were anti-operations ordinances. And while litigation was happening to determine the enforceability of those ordinances, the town board fully flipped over, and they rescinded the ordinance, ultimately mooting the case. But we anticipate, there are towns around the state that are trying to do this now. I'm fielding calls. This is from Northwest Wisconsin, kind of right along the Minnesota-Wisconsin border, but Southwest Wisconsin people are calling us. I'm talking to folks in Door County. I'm talking to folks in Central Wisconsin. It made enough news that a lot of people are looking at kind of this alternative way of protecting their communities. And so I would envision litigation that will at some point get to the point of a court of precedential value kind of weighing in and saying, these towns have the authority and the ability to protect the health and welfare of their constituents. So really interesting stuff. We've got a lot of kind of moving parts and irons in the fire. But, up in Wisconsin, we're trying to comprehensively regulate this at the local and state level. There we go.
Thank you.
Yeah, sorry I'm a bit long.
Thank you. And I think as I hear all this, if this was human waste, if you have a septic system failing, health department comes out, you fix it. How in the heck do we continue to put all this manure in the ground and fighting it from after the fact instead of treating it before the fact? Makes no sense to me. But anyway, I want to introduce Katie Garvey and the Environmental Law and Policy Center, the amazing people there that have done so much on the TMDL and so much for our watershed in bringing up issues that exist in the watershed, litigating them, and trying to help us out. Eternally grateful to that organization. And Katie, we're happy to have you here today. And she's going to talk about Michigan today because they also work a lot in Michigan and letting us know what's going on there.
Yes, hi, everybody. As well, Alexis helps pull up my deck. I'll just introduce myself a little bit and the Environmental Law and Policy Center. We are thank you, awesome. We are a Midwest-based law and policy center. If you follow local politics here, you might have seen that yesterday we, along with the city of Toledo and the Lucas County Board of Commissioners, filed a lawsuit against the US EPA for their in our view, legally wrongful approval of Ohio's legally defective total maximum daily load, or TMDL. We can talk a little bit about that. And if anybody wants to talk about the case, I'm happy to chat with them. I'll be here today. I also wanted to but I'm, as Sandy said, I'm really going to focus on Michigan here, but I did want to, there was a press conference yesterday that our co-plaintiffs, the Lucas County Board and the city of Toledo had yesterday. And one of the commissioners had a quote that I just wanted to start with. And You're gonna hear about this from, more from Professor Eichert, probably other folks. But, Commissioner Gerken said, some people call them farmers, but just like any other factory, they produce massive amounts of waste. And that's really kind of the heart of, from our perspective, we're a law firm. There's just a legal difference between a farm and a CAFO. And a CAFO is legally different under federal law. And we just, as a matter of practice, have sort of elided that distinction. And we just need to get real, and we need to just start regulating these like the polluters that they are. So we recently issued a report all about CAFOs in Michigan. It's a very comprehensive report, so I won't be able to cover everything. It was amazing to hear from Kathy. She knows so much. Adam knows everything about Wisconsin, and also he knows everything. He knows every single statute by number in his brain. I work really closely with Adam, and every time I'm just like, how do you remember all these things? But so I'm not gonna be able to cover everything, that's for sure, but this report is really comprehensive. So go there. If you have questions still beyond that, obviously I'm happy to talk about it and answer any other questions. So it's really the purpose of the report was to give a really comprehensive overview of these three things: how CAFOs cause water pollution, how CAFOs are inadequately regulated, and therefore they receive unfair legal and economic advantages. And then our recommendations from a legal perspective of what are some steps that can be taken that are not being taken right now. The report contains a lot of fun facts. There's been a lot of stats about how much manure is produced. What is manure? We really don't usually use the word manure. It's CAFO waste, because it's not just manure. Manure sort of has this folksy term to it that it's pee and poop, it's natural, it's part of farming, but this is really industrial scale waste. So we generally call it, CAFO waste. But just as a fun fact, Michigan's 290 CAFOs generate 63 million pounds of fecal waste per day. That is more than the entire state's population of 10 million humans. We have a lot of drawings and sort of images to try to pull out complex ideas, including the one that's up here, and one that if you're from Ohio, you also know is super, super critical: tile drainage, how tile drainage works, and how that basically mainlines nutrients from the land surface into subsurface piping and then directly into surface waters. So I'm going to try to, excuse me, I'm getting over this really bad cough. I'm going to try to breeze through most of this, but the report really focuses on the fact that there's been one approach that many states across the country, and especially here in the Midwest, have been trying, and that is trying to push farmers of any size to adopt voluntary BMPs, or best management practices. And it's just not working. The jury's not out. The data is clear. The water is not getting better. Many common BMPs, one of the reasons it's not working is because many common BMPs actually can make pollution worse. Some BMPs were designed to stop particulate phosphorus, and they actually make the loss of dissolved reactive phosphorus worse. Much smarter folks than me, like Jeff Reuter and others, can talk about this and the distinction and why it matters. But I think people can think, we've spent 20 years on this. We've spent, each state has probably spent, over $500 million or more. Why isn't it getting better? That's one of the reasons that there just needs to be an acknowledgement and understanding of that local hydrogeology and like local land practices really matter. And there's also limited interest from producers to adopt these BMPs. Again, smarter folks than me, like Professor Eichert, can talk about this, but when you live in a modern agricultural society where get big or get out, adopting more practices that slows down your efficiency and your effectiveness, it goes against your bottom line, and it's really difficult. The director of MDARD, which is Michigan's Department of Ag, actually has a lot of really great quotes where he says, it's basically not a mystery to him why more farmers don't want to adopt this. It costs money and they're barely, they're barely staying in business, especially a lot of these small scale farmers. So all this investment hasn't happened. One thing we haven't tried is to actually regulate CAFOs like the industrial scale polluters that they are, which would require them to fully internalize the cost of their waste management practices. So that's the overall recommendation is like, hey, we haven't tried that one. Let's give that one a shot. So even more specifically in the report, we have these sort of 4, recommendations. I'll let you sort of read through them. And again, there's a lot more detail in the report. But it really touches on things that Adam and Kathy have both touched on. One is that there finally was a TMDL developed here in Ohio. The Michigan portion, even though Michigan has developed a lot of TMDLs, including a really comprehensive statewide TMDL on E. coli, that approximately 50% of the state or water in the state of Michigan is impaired by E. coli, but they have not done a comprehensive TMDL for nutrients. So that's one of our primary recommendations. The CAFO permits, which I'll talk about a lot more later, need to get better. Eagle's enforcement of those permits need to get a lot better, which Adam touched on. And then we just need to stop spending money on things that aren't working. There's also another area that a lot of folks sort of think, oh, we need to develop a technology. There's this new solid liquid separator. There's this new thing. Maybe that could change the thing. But it all boils down to, if you don't regulate an industry, why would they adopt a technology that costs more than $0 to reduce their pollution when they are not required to reduce their pollution? It's just a sort of basic common sense situation. So Michigan does require all large CAFOs, and so those are the ones sort of hitting those thresholds that Kathy shared at the beginning. It's 1,000 beef cattle, 700 dairy cattle, 125,000 chickens, and so on. Does require them all to get permits. They are NIPDES permits, so the Clean Water Act NIPDES permits. And it's Michigan's permitting system is kind of a little bit the opposite of what we heard about in Wisconsin, where every CAFO gets an individual permit. In Michigan, it's kind of the opposite. 88% of Michigan CAFOs get coverage under the general CAFO permit. So that permit is reissued every 5 years. So when that comes out, it's kind of a big deal because it covers most of the CAFOs. There is a significant, there's a statutorily, or I guess maybe regulatorily required period of public engagement. On top of that, when the 2020 permit came out, Eagle actually engaged in a pre-draft, very extensive public engagement period. They had months and months of listening sessions. They went around, they talked to people all across the state. They issued a draft. There was a formal public comment period. And then at the end of it, that draft that they issued was a real step forward. It wasn't as far as we thought it should go. We intervened in a lawsuit to say, you need to go further, but it was a real step forward. But they got a lot of pushback from the industry. So when they issued the final report, they actually pulled back some of those steps forward that they had made. So there have been a number of legal challenges to that 2020 permit. There is a very clearly defined legal process for challenging a permit in the Michigan Administrative Procedure Act. And the CAFO industry filed a challenge it's called a contested case hearing or an administrative challenge. They filed that. We, on behalf of ourselves and a number of other organizations in Michigan, community organizations, other environmental organizations, we also participated in that case. Again, we were taking the position that the permit was totally fine, that if there's nothing that they should allow the permit to go into effect. But as a matter of fact, it needed to go farther. And so we had specific arguments about what the permit needed to include that went further. But so that's the legally prescribed available route to challenge a permit that you don't like. The CAFO industry also just went directly to court and filed a parallel lawsuit in the Court of Claims. And that only involved, excuse me, Eagle, Michigan's Eagle. And there was no intervention for outside parties. So what happened was the contested case hearing, that proceeded, there was a 3-week trial. The administrative law judge heard tons and tons of evidence from all sides about how, CAFOs pollute water, the science, the hydrogeology of the particular region. But then separately in parallel, this legal challenge was going up through the court system. And by the time the administrative law judge was in a place to make a ruling, that case had gone up to the Court of Appeals in Michigan. Oh, thank you. And so the administrative law judge said, wow, okay, so there are appellate courts, thank you so much, handling this and looking at this issue. And the courts, the administrative court stayed the decision. And eventually it went all the way up to the Michigan Supreme Court. We intervened, we didn't intervene, excuse me. We filed what's called an amicus brief, a friend of the court brief. The parties and we were allowed to argue in January. And so now that case is taken under advisement by the Supreme Court. We anticipate a ruling sometime by the end of the summer. And what the court does in that case could have really significant impacts, not just on CAFO permits, but really any environmental permit in Michigan. The slaughterhouse industry has already relied on the victory that they got, that the CAFOs got at the appellate court level to argue that their new general permit was invalid and that Eagle's not allowed to make their permit more strict at all and that you can't change anything about their permit. Now, well, as I mentioned, we did the report, and in that report, we laid out what our recommendations are going to be for the 2025 permit, which is really coming up, and it's an interesting thing to just take a step back and look at the timing. The 2020 permit came out, it's now 2024, and it's still tied up in legal challenges, which means that this whole time, the 2015 permit, which the state of Michigan has acknowledged was not sufficient to protect water, that has been the only permit that's been in effect this entire time. And so basically, the industry has gained an additional 4 years of avoiding regulation through these legal challenges to the permit. So I won't go into the details here. I did want to just touch a little bit on local control, because I know that's an issue that Sandy mentioned would be of interest to folks. So in Wisconsin, you heard about there's these local ordinances, operations ordinances that some towns are looking into adopting. Unfortunately, that's not really available in Michigan. Michigan has a right to farm act. A lot of states do, I think it's 47 states do. This is at a very high level what the right to farm acts do. They're ostensibly passed to protect farmers from nuisance lawsuits from their nosy neighbors who just don't like the smell of manure. But in fact, what they are is they really provide extreme legal shields to these industrial scale polluters. I'm going to talk a little bit about this last piece, which is about the local control. Michigan's, now not every right to farm act does it this way, but the way the Michigan right to farm act works is they said, okay, here's all this stuff about nuisance and whatever. Also, we are requiring this Michigan Ag Department to develop what's called a set of GAMPs, the Generally Accepted Agricultural Management Practices. And then basically, if a farmer follows the GAMPs and they get sued for a nuisance suit, they get to say it's a total shield. They said, nope, I followed the GAMPs, you can't sue me. So whatever I did doesn't, violate the law. But one of the other impacts of developing this set of GAMPs is that the Right to Farm Act also says local governments can't adopt any requirements that conflict or overlap with the GAMPs. So basically the GAMPs come in and they set this minimum that is simultaneously a floor and a ceiling. So if you are compliant with the GAMPs, you're compliant with the GAMPs, and a town, let's say a town wanted to put more stringent disease prevention measures in place for with the H1N1 situation that's going on. that might be blocked because there's a GAMP called Care of Farm Animals, which lay out extremely minimal requirements around disease control on livestock facilities. Another example here is the manure management GAMP. There's currently no statewide setbacks for residences, churches, et cetera. So if a town wanted to say, okay, we want to put a 200-foot setback or whatever, you can't, have manure within 200 feet of a church or a school or a home or whatever, that would probably be blocked because there's a manure management GAMP that says, no, manure can be stockpiled anywhere as long as there's a tarp, fleece blanket, or straw cover on it. So there's just, it's this sort of simultaneous floor and ceiling thing that really robs local control opportunities. So you can see this is the set of things that GAMPS covers. And one, in terms of local control that's really impactful is the site selection GAMP. And that really, that covers, sorry, I'm just gonna take a minute, drink some water. The site selection GAMP covers where livestock facilities can be sited. So again, local municipalities can't say where they can and can't be sited. A livestock facility goes through this process, which is completely within the Department of Agriculture, which, as Kathy pointed out, the Department of Ag's job is to promote farming and agricultural practices. And as long as they meet these minimal standards within the GAMPs, the facility siting is going to be approved. And the GAMPs committee has explicitly said that these things that are going to be really important to communities, like air pollution, transportation, noise, zoonotic disease concerns, those are things that the GAMPs committee cannot consider when they make siting decisions. It's kind of, you can appeal, there's an appellate route available within MDARD. Again, MDARD is the Ag Department, but there's no the avenue for judicial review. So the Department of Ag basically gets the final say. So I kind of wanted to plow through that because I know there's going to be a lot of questions at the end. So I will finish that. Thank you.